Number 112549, State of Kansas v. Willie Fleming.
May it please the court, Peter Meharry for Willie Fleming. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted.
Thank you. This case comes by way of petition for review. Mr. Fleming was convicted of aggravated robbery and aggravated burglary. He was sentenced to 248 months incarceration. The charges arose out of a home burglary in Johnson County. Several individuals went into a house. 2 individuals were in the house. One was the owner and one was a guest. The individuals that went into the house took various items. Eventually that led the police to my client as well as 3 other individuals that they charged arising from that home burglary. As it comes to this court, we raised 3 issues in the Court of Appeals. The Court of Appeals ultimately affirmed. We filed a petition for review, and this court granted petition on the first issue in our brief, and that was whether or not the instruction on the aggravated robbery charge was proper. We have asserted that the instruction given was improper in that it was broader than the complaint itself. Specifically, the complaint charged my client as far as the aggravated robbery charge from taking property, specifically a cell phone and wallet. The instruction given at trial, however, instructed the jury that to find my client guilty of aggravated robbery, they just had to find he took, quote, property, a generic property instruction. The Court of Appeals was a 2-to-1. I guess it wasn't a split, there was a concurrence, but the majority did not reach the merits of the issue. They found that any complaints about the instruction were invited by defense counsel. The instruction given was, as far as the language dealing with property, identical to the instruction proposed by defense counsel. Both the state and defense counsel proposed basically the same instruction.
Was it identical?
It wasn't quite identical in that the instruction was presence. Specifically, defendant knowingly took property from the presence of Carrington.
That was the instruction, but your request was different than that, wasn't it?
It was from the person, I believe, person or presence of Carrington Dean, I believe. But the property
Are you
was
saying
the
that's
same.
not a significant, I mean, that's a distinction without a difference?
I kick myself later, but as far as this argument goes, it makes a difference on the invited error in that...
Does it make a difference, though, even in the instruction itself? It seems to me it does, but you're kind of saying it doesn't.
I think as far as the invited error doctrine goes, the Court of Appeals said my client invited this error because the instruction given was what my client asked for, which is not exactly the case.
Well, what are you complaining about? And isn't that the problem here? You're complaining about the part that you suggested to the district court.
The
So
part
that's why
about
invited error comes into play.
the part about property, the instruction my client attorney requested was defendant knowingly took property. That part was given, and that is the part that we have a problem with because in the instruction it's generic property. In the complaint it is very specific property.
And when counsel submitted that instruction, it was at that point obvious that it was a broader instruction, proposed instruction than the charged as charged.
I don't know if it was obvious to the attorney at the time. I think what the attorney probably did is just submit basically a generic PIC instruction on aggravated robbery.
But okay, so I'm taking the subjective view out of it, but just objectively, somebody could have held that instruction, compared it to the charging instrument, and seen that the language was different.
Certainly they could have. The language in the complaint was specific as to the property taken. It had the to wit language, taken property to wit, cell phone, wallet. So
this isn't a situation where we need to get through the evidence to determine that there was a broader charge. then there was a broader instruction than charged.
I think the language in the instruction is clearly broader than the language in the complaint. By using just the generic term property, that is much broader than what the language was, which was very specific in the complaint. So I don't think you have to look at the evidence necessarily to make that determination. I think you can just look at the language of the instruction and the language of the complaint.
And so even under Hargrove, which you rely on, doesn't that hurt you?
I think what Hargrove looks at is almost more of a balancing of the interest, what you're dealing with, and whether or not you should apply the invited error. And when you look at the interest involved, Hargrove talks about individual fairness, for lack of a better term, and institutional fairness. The point of the invited error rule is we don't want people saying, district court, please do this. District court does that, and then it blows up in your face, and on appeal you complain about it. The best example I can think of is somebody asked district court not to instruct on any lesser includeds, and they get rung up, and then they complain about that fact on appeal. That's what the invited error wants to prevent. But I don't think you have that in this situation when you kind of balance the interest involved. I don't think you have kind of that gaming of the system. Here, I think defense counsel just submitted what amounts to be a basic pick instruction. He wasn't seeking to invite error or insert error into this trial. I think it was more of an oversight. And when you balance that against the fundamental interests of due process, by having the possibility that my client would be convicted of something which he was not charged with, I think that weighs in favor of considering the merits of the issue. And I think that's what Hargrove kind of looked at is this a situation where defense counsel is trying to take a specific trial strategy at trial, and then when it does not work out, complain about that on appeal? I don't think just submitting a pick instruction is that. It's not really a trial strategy here.
So we just have to litigate every complaint that comes on appeal, even though the defendant offered up that action from the, I mean, if you're talking about strategy, so we just have to litigate every one of these cases. And I mean, the invited error rule is a cutoff. And I can't come up with a way to articulate a rule that doesn't just do away with the invited error rule.
And I think that's what Hargrove was trying to get at. And it may be a situation where you have to look at the specific facts of each case as to whether or not the invited error rule applies. But I think the court kind of does that anyway.
I mean, we've helped you out a lot with the Court of Appeals because we've said, you know, it's not enough to trigger the invited error rule just because you didn't object. You know, so we've gotten you that far, but when you actually submit the error to the court and the court does what you ask it to do, it just seems like you're asking the appellate court to do an awful lot of analysis for something that you requested at the lower court.
I guess I don't see it as a lot of analysis. I think you can look at the situation, and in this case, the instructions were submitted right before trial. It was, again, just a basic generic pick instruction on egg robbery. I don't think it's at all part of an overall trial strategy to get the court to do this and insert error. So I don't think it's that much work or that much analysis at the end of the day.
How do you distinguish Jones from this court, which was the case that the Court of Appeals cited and relied on? It was a counsel submitted an eyewitness instruction in the packet before trial, and we said it was invited error.
If I remember Jones right, I think that is one of those where it's more specific, where the defense counsel is making this specific request. I want this instruction. Here, I just don't think you have that when all defense counsel did was submit a packet of instructions with generic pick instructions involved. It wasn't out of the ordinary. It wasn't a special instruction. It wasn't an instruction that
And what's the point? What's the point of defense counsel just telling the district court, here's the pick, when the district court has a book with pick in it? And if defense does nothing, they get, we've already said that there's a built-in preservation. If you just stand silent, you at least get clearly erroneous.
I think the point of having both sides submit instructions is for the district court to get an idea of whether or not what instructions they do want. But I think that's tempered a little bit when you just.
So the point is to help the trial judge.
I think it's certainly to help the trial
and
judge.
if we apply the invited error rule, in addition to hurting defendants, make them have to file a 1507 for ineffective assistance of counsel, is we're going to preclude the trial judges getting both sides submitted, because I don't see any reason why you would submit and take the chance unless you have something very specific. But I see no reason to do it if we're going to find that invited error for submitted.
Well, and I think there's a difference I would draw between kind of your standard element instructions, your standard introductory instructions, and ones that are more specific to the case at hand, like an eyewitness instruction. You don't necessarily have that in every case. You do have an elements instruction in every case. And here, just submitting the generic instruction, I don't think is part of any plan or strategy at
But
trial.
how do you know?
The biggest reason I would say is it doesn't make much sense for defense counsel to submit an instruction that provides more avenues for a conviction than what is in the complaint. That doesn't make any sense to me. If the state is specific in their complaint that they have to show that my client took a cell phone and wallet, I don't know why you would want to instruct, as a defense counsel, why you would want to instruct a jury that could be a cell phone, could be a wallet, could be these other things too. That doesn't make any sense on the defense side.
Could it be
So-
because, I'm sorry, go ahead.
So doubling back to, I think it was Justice Biles' question, are you not asking this court to try to determine when someone is gaming the system and when they are not?
I think
Just based on what the record indicates, something as simple as submitting a pick instruction.
I think this court can look at the record and determine whether or not this is part of an overall trial strategy. Again, going back to my example of the lesser includeds. If the district court doesn't give any lesser includeds because the defendant got up there and said, we want to do all or nothing, that is clearly a part of a strategy. But I don't think you can say that with the instructions submitted here that were submitted just before trial, that just basically took pick and copied them and put them in and filed them with the district court.
So in this situation, if there's an acquittal, even though this instruction was not the best instruction, your client wins. And if he submitted these instructions poorly and we determine it was invited error, then we go back and do it again. So he gets to win under both scenarios, possibly.
As far as if he gets an acquittal on a poorly worded instruction,
We're done.
we're done. I think we're done. I think lots of errors get swept under the rug with an acquittal. If it's a poorly worded instruction that leads to a conviction, I think even if it's submitted by defense counsel, if it wasn't part of his overall strategy, it was through inadvertence or just didn't really think about it, this court should look at it and determine whether or not on the merits it warrants reversal. I don't know if I answered your question, but at the end of the day, my client has a constitutional right to be convicted, if it's proven, of what he is charged with. And that was not done here. The instructions allow for a conviction beyond which he was charged in the complaint.
So in our Plummer and progeny vernacular, this would be legally inappropriate?
I believe it would be legally inappropriate because the state is bound by the language within its complaint. They made a specific charge in the complaint that my client stole a cell phone and a wallet, and they are required to prove that at trial if they want a conviction on aggravated robbery.
The cases you cite for that proposition talk about changing elements. There's no change of elements here. There's just a factual change. And as the state argued, that is generally seen as a variance, not an amendment. I didn't really see a response to that other than just kind of, it seemed like you were almost arguing structural error or just of general fairness. Is that?
As far as the difference between whether or not they change the element or change the facts that support an element, I don't think this court should see a difference. And I think if you look at Trotloff, and I've quoted it in my petition for review, this court talks about being convicted upon facts that were not contemplated in the complaint.
That's because it was an alternative element, an alternative means type of situation.
But I think those different facts, even if it's the same element, if you're going to say my client, hypothetically, is charged with first-degree murder, and you charge him with killing John Doe. John Doe is the fact. The killing of the human is the element. But I don't think this court would allow it to go to trial and instruct a jury that he killed Jane Doe. I think the state is tied by the facts they put in their complaint. That is what gives my client notice of what he is to defend.
What I started to ask you when Chief Justice Ness and I spoke over each other was, isn't it possible that the reason the defense counsel didn't make an issue of this in the instructions is because everybody in the courtroom knew what was at issue? And isn't that the point that Judge Lieben makes in his concurring opinion as to why there's no harm? Is that consistently throughout the trial, through all the arguments, everything that was presented to the jury was, these are the two items that we are talking about on this charge, the cell phone and the wallet.
Judge Lieben did take that view of the evidence that there wasn't really any confusion at trial as to what they were alleging my client took. I disagree with that view of the evidence because when you go back and look at the testimony, look at the evidence presented, a considerable amount of evidence was presented as to all kinds of things taken during this robbery, not just the cell phone and the wallet.
Why is this not like an election the state makes on alternative means? We usually bind the state to what they say in their argument as to what that is. Why is there a difference in that?
I think the problem comes in, you still have the instruction which just says property. So when the jury gets back there, they have all this evidence about all these items taken during this robbery, and they have this generic instruction. All we have to find is that he took property. It doesn't say what property, and we've got all this evidence of all these things taken. So I think that's where it's a little different than an election, because you have that broad-based instruction that was given to the jury.
Any further
If I may,
questions?
just hopefully really quickly, back to invited error. Judge Lieben's opinion suggests at least that the application of invited error in a situation like this is discretionary for the appellate court. Do you agree with that?
That seems to be obviously Judge Lieben's opinion, and it seems to be the wording of the cases that I've looked. Courts talk about we opt not to or we decline to.
If it is discretionary, do we have a sort of a standard of review problem? Or what is the standard of review when the Supreme Court is reviewing a court of appeals? I mean, we don't normally talk about an appellate court's discretionary decision, but this might be one of those rare circumstances. How do we handle that?
I would think that this court's review would be de novo.
Right, I knew that's what you were going
Yeah.
to say, but it seems counterintuitive to say the lower court exercised its discretion to apply a doctrine, and then shouldn't we be reviewing that for abuse of discretion, typically?
The invited error rule is a judicially made rule. So in that sense, I think
Would we have to say that the Court of Appeals applying invited error in this case was an error of law to get to the merits? Wouldn't we have to do that?
I would say that the Court of Appeals did err as a matter of law because I don't think it applies in this case, given.
So you
doesn't quite
disagree
fit
with
the-
Judge Lieben's opinion where he said, sure, the majority may apply it. I just would exercise my discretion as an appellate judge differently. That's how I read the concurrence.
That's how I read the concurrence. The problem I have, I guess, is the way I read the majority is that it did not appear to me that they really considered anything beyond the fact that the language regarding property was within the instruction submitted by the defense counsel. They didn't do any weighing or consideration of all the other factors that I think should go into play. So to the extent that I don't think they did a proper analysis, I think they did err as a matter of law, and just kind of as a matter of course applied invited error without the proper analysis.
Thank you.
Any further questions? Thank you, counsel.
May it please the court, Sean Minahan for the state. I understand Mr. Meharry's argument that, well, if the defendant has a strategic reason for asking for a certain jury instruction or for asking that it not be submitted or for it to be changed, that should be invited error. But that really doesn't get to the whole rationale behind the invited error rule, which is that we don't want defense counsel or the state, and in civil cases, either side, ceding the trial with error and then coming up on appeal and saying that, oh, this was an error and you should reverse. And
Before we get into invited error, would you tell me if this was error? Was the instruction erroneous? And if it was erroneous, was it factually inappropriate or legally inappropriate? I think, to me, it impacts me because of the inability of the parties to stipulate to a legal error. And so, first, was it error? And if so, legally or factually?
That's really hard because there's not a lot of guidance on, in a complaint, what has to be put in the complaint as far as facts are concerned. And then once they're put in, does that matter when it comes to the jury trial? Because you're talking about really about notice to the defendant in this case. But I think in this situation, at least what the case law says right now is if you charge certain facts in the complaint, that's what you're bound by. And so as far as those cases are concerned, I would say that it's error, but it's a factual error because it wasn't a change in the elements of the offense.
But that rule applies not just to the facts of this case, but it applies to any case.
Right.
And so how do you say it's a factually inappropriate in this case when the rule applies, the rule of no broader elements instruction than the facts stated in the complaint? That's what you're saying the rule is, right?
Right.
And that rule applies to every case.
Right.
So I don't say, why is it factually inappropriate in this case, but it would be factually inappropriate in every case? So
I guess
why
maybe I shouldn't have used this case.
Yeah.
I think it's factually, like, as the case law stands right now, if you charge it in the complaint, the facts, those certain facts that you're required to limit the jury instruction or limit your argument at trial to those facts.
Are you abandoning your variance argument that you made in your brief before the Court of Appeals?
No.
And that I'm confused then as to your answers to Justice Johnson.
Okay.
Why is this not a variance that's not an error?
That's what I'm saying. That this varies from the jury instruction. I guess I was confusing when I was talking about it, the case law isn't very clear on what facts have to be put in a complaint. And we know that the facts that are necessary in a complaint are ones to fairly apprise the defendant of what crime they committed. But there's no ironclad rule says, that you have to, in a theft, you have to put the exact things that were stolen. There's no ironclad. And so it makes it a little bit harder to determine, whether you have to put those in the charging document. That's kind of a theoretical argument. What I'm saying is that if you put the facts in the complaint, then that, based on the case law now, that's what you have to prove at trial. And so there is a variance problem here, a factual variance problem, is that the jury instruction was broader than the charging document, because the charging document said watch and wallet, and the jury instruction didn't. It said property. Does that make sense?
To an extent, but I think there's a lot of, and I thought you cited some case law from other jurisdictions where they say that type of variance is not error.
No, I think it says it's error, but you, and I may be wrong, maybe I read it wrong, but that it all hinges on harmlessness. And I guess a good example of this.
So you would say it's, as opposed to your opponent who seems to be arguing almost structural error, you're making that distinction, that it's not that, it's something less than that. It is error, but it can be reviewed for harmlessness.
Right, and that's what the doctrine of variances says. It doesn't make a distinction between broader elements or broader fact jury instructions. It's only concerned with, was there error? Was it broader? Was it broader fact instruction? Was it broader element instruction? And if so, was the defendant harmed by the broader fact instruction or broader element instruction? And probably the best case is a case from that talks about this, I think 2006, around there, where the defendant was charged with stealing 2 TVs. And at trial, they instructed on him stealing 3 TVs. And the Court of Appeals reversed, saying that, well, that's the difference between a felony and misdemeanor. It could be, between stealing 3 TVs could go over the $1,000, the $15,000 or $1,500 level, and it could change the crime from a misdemeanor to a felony. There's a case where the defendant would actually be harmed by a broader fact instruction. And as to the invited error, we're not only concerned with the strategic decisions, but it's also the defense attorney who's gaming the system, trying to seed the error. And the remedy really isn't in the Court of Appeals or the Supreme Court, where we don't have any evidence on what his intent was. The defense attorney, it's an IAC claim. You go back to the district court, you hold an ineffective assistance of counsel claim, you put the attorney on the stand, and he can testify whether this was strategic or whether, this was incidental, things like that. So I don't think that, I think that this should apply to not only strategic issues, but
what's your opinion or position on the standard of review question that I asked your opposing counsel?
I think it should be abuse of discretion.
Do we ever do that? Have we ever done that before, where we say we review a Court of Appeals decision for an abuse of discretion?
I do not know. I don't think I've ever seen one.
A Court of Appeals decision to apply a prudential.
Right.
Yeah.
Kind of the interesting follow-up to that question is if the court has discretion to decide which cases to consider and which cases to apply the invited error rule, what's the standard for determining?
Right, that's what I'm kind of trying to drive
Well,
at. And it really does arise out of Judge Liebman's concurring opinion. And it's really that kind of interesting question is there such a thing as an appellate court's discretionary choice to apply a doctrine or not apply it.
Right, and what's the test?
Well,
How-
surely
why-
there is, because we've got exceptions for raising issues for the first time on appeal.
Right.
And we can do, and they're not mandatory. It's just whether we think there's some sort of an injustice is one of them. And that would seem to be a exercise of discretion when at its first blush, at the, let's just say at the Court of Appeals. I've always wanted to talk about when it comes up and they made that, exercised that exception. Are we supposed to review that for an abuse of discretion, or are we supposed to do it on our own?
I think the abuse of discretion. I guess my concern is that there's not really, what one panel of the Court of Appeals may think that there's an injustice in a case, another panel will say no. And so there's no real, I'm not sure injustice is a real test to determine which ones deserve
Well,
to
that's
be
why it's
considered.
within just a judge's
Yeah,
discretion.
that's kind of
the
the
point of discretion, right?
Yeah, but I'm not. Usually, that doesn't happen in Court of Appeals, in appellate courts.
And we have to remember the context in which we're trying to apply it. Because as we've said, the instruction errors are a whole different animal. The legislature has included a preservation or a right to appeal without preserving. Whereas, it would seem to me that applying the invited error in that area where the defendant doesn't even have to preserve the issue, if it's clearly erroneous, has got to be a little bit different than other errors. I mean, all three in the courtroom can be mistaken, and we still consider it.
Right.
Right? And so what we have here, that's exactly what happened. All three of the defense, the prosecution, and the judge, if it was wrong, all three got it wrong without a fight. And it seems to me the instruction says that, hey, if it's clearly erroneous, you can consider it, albeit with the huge hurdle of being firmly convinced that it would have had a different result.
But then I guess that kills all invited error in jury instruction, doesn't it? I think it does.
Well, but how do you jive that with what the legislature said? It says unless it's clearly erroneous. And, legislature has said we can consider clearly erroneous. And so when we say invited error, we're really not following the statute to determine if it's clearly erroneous, are we?
The invited error doctrine is a doctrine outside of the statutory scheme. And
I understand that.
And it's focused on not allowing defense attorneys in criminal cases to, and I don't know, could a state do it? I don't know. To cede the trial with errors and then complain about it on appeal. I mean, so it's outside the statute.
Are we splitting hairs to say that it's prudential and that you can choose not to apply it in a situation where it's not warranted? If the instruction is egregiously erroneous, then what difference are we if we're considering whether it's clearly erroneous? I mean, it seems to me that if we're considering whether this was really, really bad instruction, to apply the invited error, why are we going through that instead?
Well,
Do you understand what I'm trying to ask?
Yeah, I think so. You're saying that because if we found that it's clearly erroneous, why wouldn't we consider it and reverse it? Because we found that we're firmly convinced that
it would have changed and it's prudential doctrine. If we're finding it's a prudential doctrine, I think it's a superfluous intermediate step.
Right, but I would argue that even there's situations where a defendant may be able to prove that they're not guilty of a crime, And if they plead, we don't care. They've pled to it, even if they can prove that they're not guilty of the crime. And so there's situations where that's not enough. And so I think that really points to it's not whether he may be not guilty of the crime or the state didn't prove it up. They've made their bed when they've chosen that jury instruction.
And the difference in your analog is that the legislature, instead of saying that we can review whether that plea was clearly erroneous, has said you can't appeal a guilty plea. And so we have a different statutory paradigm with regard to, that's what I'm getting back to.
Right.
We have a very unique statute that we've interpreted to say you don't have to preserve if it's clearly erroneous.
Right. But I still think that, I guess I still think that the invited error doctrine is outside the statutory scheme, and it's a means of, I don't want to say punishing, but not giving, a defense attorney or a defendant his cake and letting him eat it too.
I've always understood it to be distinct from the statutory scheme, because it talks about, it's more about requesting something, seeking something out actively, as opposed to the statute, the clearly erroneous statute, talks about failure to object, doesn't it?
Right.
Which is something less.
Right.
In terms of either defendant or defense counsel's involvement than asking for something to happen.
Right.
Can I take you back to your interaction with Justice Lukert
Sure.
earlier? It's not clear to me. Was the instruction erroneous?
Yes.
I mean, it was erroneous. And
No, the jury instruction was
Yes.
factually erroneous.
it was actually erroneous, but the error was harmless, is what
Right.
you're saying, based upon this variance
Right.
position. Okay, I just want to be
Yeah,
clear.
I guess I
So
should have
in
brought up-
Justice Johnson's scenario, all three were wrong. The court, the state, and defense counsel were wrong in giving this instruction.
Right.
Okay.
But it's invited error, and the remedy is to have an IEC hearing in the district court to show for the defense attorney to get up there, if any remedy, to get up there and testify to why he chose that instruction. I mean, that's really where it should go.
Does it make any difference if both the state and defense agree to recommend? Then the defendant's precluded by invited error?
I don't think so.
It doesn't make any difference if everyone's mistaken about what's appropriate and they recommend to the judge to help the judge get the instructions together. I mean, that's what happens. The only reason the attorneys are there to help the court get it right,
Right.
and get it put together. And but then still the defendant's the one that loses the right to get a clearly erroneous instruction reviewed.
Well, it's not like he's being forever forbidden from raising this issue. He still has the ability to raise it in a 1507 that his attorney was ineffective for not requesting a proper instruction, and if so, whether he was prejudiced by it.
What's the prudential value of ignoring, just applying the invited error rule now, and then, which would possibly require going back and doing the IAC hearing? Doesn't it make more sense, for at least from a judicial economy standpoint, for us, if we accept your position, which is that this is a harmless error, why wouldn't we just move on and say, and do an evaluation of that question?
Because you have no information before you on the rationale behind the defense attorney's choice of that instruction.
But that's not relevant to harmlessness. Who cares what his motivation was? He or she. I mean, it's completely irrelevant to the harmlessness analysis. You understand what she's saying? Why do two causes of action?
Yeah, I
Why
understand
do
what you're
two
saying, but
why do a criminal prosecution and then a
It is
1507.
relevant to an IAC claim.
It is, but she's
and if
asking a
it's a-
different question. She's saying, why bother to force the defendant into that position to go litigate it in a 1507 if we can look at it today and say this is not clearly erroneous. It's not reversible. Which is your backup position, isn't it? Plan
Right.
B. Yeah.
Yeah.
So she's just asking an economy question.
Because they can turn around and raise it in 1507 again, first of all.
I don't think we're communicating.
Yeah,
She's asking,
maybe-
what's the point of forcing that? What's the judicial economy in forcing a second action if we can answer the question on its merits today? That's what she's
Because
asking.
they'll raise it in a second action as an IAC claim still. We'll still get that issue
I understand
in the
we'll get
district
the
court.
issue, but we'll get it after years and a second action. She's asking, what's the point of employing a
Prudential rationale under invited error to block the claim today if it'll force that action to come later? When we can look at if we can look at it today and say we're going to excuse the invited error, which in theory we can do if it's prudential, we can excuse the invited error, we're going to go ahead and reach the merits and we're going to reject the claim on the merits today.
Because even if you do that, even if you say Prudential allows us to consider this, they are still going to file a 1507 and they're still going to raise this issue as an IAC claim later. So you're doubling up.
You don't avoid it. Is what
You don't avoid it
Got it.
by, I'm sorry, I should have done a better job of explaining what.
Don't avoid it gets
Yeah, it doesn't avoid having the 1507 later, where they say, oh, well, maybe this wasn't a clear error case, but my attorney was ineffective for that, and it affected the outcome of this case.
Well, the 1507 comes in and said he or she should have objected, so I didn't have to face clear error when I got up in the appellate court
Right.
on this error.
Right, so you're really doubling up a decision when you do that. So, and I have run out of time unless.
Can you address harmlessness? So,
Yeah,
Did you get to that point?
Yeah, everybody was clear at this trial that it was the wallet and I think it's a watch that was taken from Carrington Dean in this case were the things that were stolen from him. I think even Judge Levin pointed out in his opinion that that's what the state argued in its closing argument. Judge Levin also talks about, well, there's this scenario where he may have taken things from Davis, but that's not likely. Well, the defendant was acquitted of having stolen items from Davis. So the jury necessarily found that no items were stolen from Davis. So that gets you right back to the wallet and the watch as the only items taken. So I think it's harmless.
Any more questions? Thank you, counsel.
Unless this court has any additional questions, I don't really have any further presentation on this issue.
Any more questions? All right, thank you, counsel.
Thank you.
I appreciate the arguments of all counsel this morning. Court will take this matter under advisement.